This program was made possible by the law firm of Zalman and Schnorman, whose practice is limited to personal injury and insurance law. Welcome to Lawline with your host, Alan Schnorman. Mr. Schnorman is a distinguished trial attorney, author, and lecturer. Each week, Lawline will bring you the most knowledgeable experts in the field of law today. And now, we introduce our guests and our host, Alan Schnorman.
Welcome to Lawline. Vindictive, controlling, intrusive, and autocratic are just some of the terms used by apartment owners to describe their co-op boards. Today we're going to look at some of the pros and cons of co-op living and see if we can find out why co-op boards have such a bad rap. Our guests are Ezra Goodman, a real estate attorney who represents many co-op boards, and Ken Newman. Ken is president of his co-op board and is also a real estate attorney. Ken, you heard the introduction. Why do co-op boards get such a rap?
Well, I think the problem is that everybody wants to do their own thing and they want their own way. And the co-op board's function is to look out for the benefit of the building as a whole and not for the interests of an individual shareholder, although they are always to be considered.
Ezra, co-op boards today, from what I understand the state of the law, have almost virtual control over their particular unit. It's almost like they are the legislature of their building. To get into a co-op, you have to go before a co-op, and from what I understand, they can turn you down for almost any reason. Can you comment on that?
Well, it is true that the co-op structure is the corporate structure, and there is a lot of discussion as to whether that is really an appropriate structure for what is essentially a residential community rather than a corporation such as the normal stock corporation. But the structure as it exists does allow the board of directors a very substantial amount of discretion and authority, including the right to reject somebody. And in New York, you don't have to give a reason as to why you reject anybody. However, any board that has any sense, if they should reject someone, really has to be clear in its own mind and in its own records as to why it was done, because there is an increasing number of lawsuits and complaints filed with Human Rights Commission and so on in regard to these
Let's
matters.
assume I have two teenage children, and as teenage children they make noise and they bring friends and they stay up late and they play their radio. Can the board reject me because I have children?
Well, your marital status and the fact that you have children in and of itself really cannot be a ground for the board rejecting you. However, the board does have the right to investigate your references, to see how you behaved at your prior residence or accommodation, and if you prove to be a problem there, or at least if your children prove to be a problem there, then they would have the right to say no.
Do they have to tell me why they're saying no?
No, they do not have to tell you why they're saying no. However, if you want to pursue the matter, eventually they will have to tell you. If you take it to the point of either filing a complaint or taking them to court, as I say, as more and more people seem to be doing, because the list of categories which can be offended and which have a right to take that position is growing. As an example, occupation is something that was added a few years ago to the list of protected categories in the city of New York, and I must say that I think it was done primarily because so many lawyers were being rejected by co-ops.
Ken, it's been reported, and some of my friends have said that people go on boards, which is not a paying position, as a power trip, as an ego trip. How do you respond to that?
Well, I don't think it's a power trip. I think that actually co-ops are lucky to get people on boards because most of the time there aren't enough people who are willing to devote their time, effort, and services, which is always uncompensated, but sometimes not even liked.
So you don't feel that this is an ego thing? Why do you go on? Why did you go up become president?
Protect my investment, and because I found it an interesting and rewarding experience.
And when someone comes before you, now I want to go into your building. I know it's a nice building on Bleecker Street with over 100 units, and I've always wanted to live in Greenwich Village. What criteria do you use to either reject or accept me?
Well, the first criteria that I would look at is the financial aspects of the applicant.
Well, I have enough money to buy it.
Not always. Some people have just barely enough money to close the deal with the benefit of a 90% mortgage.
Okay, so let's assume I have enough money.
Once you have enough money, not necessarily. Then we look at your references.
What do you mean references?
Well, we want to make sure that you have a stable job and have not caused a problem in other housing circumstances.
Okay. Let's assume I have a stable job. I've been working with the same job for 6 years. I make a reasonably good living.
In our co-op, you would get in.
Let me just say that not in every co-op would you get in. I had a case, in fact, where an attorney applied to a co-op and was rejected. He filed a complaint with the Human Rights Commission claiming he was rejected because he was an attorney in occupational discrimination. And when the matter came to me, I asked the board, why did you reject this fellow? He seemed to have all the criteria. And the answer was he was obnoxious. We didn't like him. Now that happens to be a perfectly legal reason for rejecting the person. We went to the hearing before the Human Rights Commission, and as it turned out, luckily, 3 out of the 4 attorneys who had applied to this co-op had been accepted, and this fellow had been rejected. So he lost the case, and we won.
Are you saying that they have a right to reject people just because they don't want to travel in the elevators with them?
Yes. As long as you don't violate one of the protected categories, which, as I say, is an expanding list, then you can reject somebody. And this is where some of the tension comes in. The basic notion of the co-op as a residential community in many ways is at odds with the life experiences of people as they exist today.
Now,
I think it goes back to an earlier time.
Karen, I've also heard that sometimes board members use this power that they have over who can get in and who cannot get in as who they like and or who they dislike. If someone who is selling their apartment has a fight with somebody on the board, and they've had their unit on the market for months or even over a year, and they bring somebody to you, do you have the power just to reject it because you don't like the person who's selling it and you want to get back at him?
Well, I would say yes, you do have the power to do that, but you have to remember that boards are an aggregate of a number of people, and it's no one person who would cause somebody to be rejected. So you would have to offend an entire board or a substantial number of the board to have your person
Or a
rejected.
very powerful person on the board. I want to go back to something you asked earlier, the question of power trips and ego. I think that does play a role in the way people, or the reason people go on boards, and there's not necessarily anything wrong with that. People need sometimes that kind of motivation to go out of their way and serve on a board without pay, as Ken said, and very often subject to a lot of criticism by their neighbors. And there is a certain satisfaction that they get in having a controlling role in where they live. However, they also have to be careful not to injure the interests of the co-op. If boards develop a reputation for turning people down totally arbitrarily, or for taking much too long in processing or approving their application, the market value of their apartments are in jeopardy.
Now, Ken, I've also heard that some co-ops, let's assume I get in. I get past this committee, and my references are good, and my mother gave me a nice note. And then all of a sudden I get in and I get a letter from the board that my wife is not allowed to cook with a wok. Is that what can you do that? Do you do that? Do you have those restrictions? House rules?
We have house rules, and we have the right to restrict certain activities, and we do exercise those rights, but only when called upon to do so because of a circumstance where the behavior is offending somebody or endangering the building.
Yeah, but what's offending to you may not be offending. Let's assume I love Chinese cooking.
You're talking about just because of an adverse smell in the building?
Yes.
I would imagine that would be something that we would try to negotiate a resolution of, but not try to use heavy-handed
Does he have the
tactics.
right to stop me from cooking with a wok?
As long as the odors stay within the apartment and it's just for the enjoyment of you and your family, I would say not. But if the odors escape the apartment and start offending other people, actually, it's not the cooking that's the problem in most of these buildings, it's the noise. That is probably the single most continuous complaint that we hear. People upstairs are making noise, the kids run around at all hours of the night, and to try and mediate those things is very difficult. Sometimes it's successful, sometimes it's not. At a point, though, the co-op does have to take a position if there is a verified complaint, if you've done an investigation and you verify that people are making an excessive amount of noise, then it is your obligation to do something about it, or else you face the possibility of having the shareholder that is suffering the noise invoke the warranty of habitability, withhold a portion of the maintenance charges, and then you're off and running on that tack.
Now, Ken,
And we've been threatened by suits from people who are very offended by generally very offensive behavior.
what do you mean?
So we're forced to act.
Oh, in other words, that the upstairs neighbor is making noise, and unless you stop it, I'm going to sue you?
Is playing the piano through the night and having accompanying instruments come in.
Oh, a little
Play
combo. That
A
sounds
jam
nice.
session.
Well,
And what did you do in that case?
we brought a lawsuit against the offending tenant.
That's your own shareholder.
That's our own shareholder, because he was offending a number of other tenants. We applied for an injunction, and unfortunately, we did not get the injunction.
Obviously, the judge liked the music.
The judge, it happened, said that she had been a victim of the same circumstance, and the offending behavior was not stopped in her lawsuit either.
Okay, so she wasn't going to stop this one. So
did
you
not
still have
stop
the...
this one.
What
No.
happened eventually?
Well, we changed our bylaws and made our noise rules much more restrictive.
Is that right?
Now, some co-ops have requirements, for example, that 80% of the floors have to be carpeted, it does vary from one place to another. In fact, there was a series of articles. There was an article in the Times about living next door to a concert pianist, and some people enjoy it, and some people get very offended by the noise. And it's very hard to know how people will react, you know, to these various situations.
Let's
The
see if I
co-op is usually
understand.
caught in the middle.
A co-op board can mandate whether or not I have rugs on my floor or carpets on my floor, or I have stone?
It's a fairly standard provision in house rules that 80% of floors be carpeted. Many co-ops have that requirement. And of course, the reason is to try and alleviate the sound problem.
Ken,
The problem is we're forced to take a position by the law.
let me ask you something. Why did you decide to live in a co-op as opposed to a condo where you wouldn't have to go before a board, where you may not have all these house rules? Why did you decide?
Well, the reason I decided is because the building that I wanted to move into happened to be a co-op. But there are a lot of reasons to decide for one or the other, and I would say that most people probably aren't familiar with those reasons because there aren't enough condos around, and there isn't...
Is it that a co-op is more elitist?
No, I think the...
I wouldn't say that at all.
The difference between co-op and condominium, I think, is narrowing when it comes to the point of people's behavior. They're certainly very different in their legal structures. You own your unit in a condominium, you have your own separate mortgage, you pay taxes separately, but you're still living in a high-rise building with a lot of people around you. Condominiums also have house rules, and the house rules in condominiums very often are very much similar to the house rules in co-ops.
Let's get back to this co-op versus condo and whether or not there is other reasons. Why do people decide to go into a co-op which has all these restrictions, which you have to go before a board, where they have the right to decide who their neighbors are going to be? I assume that's what you just said.
Correct. There are several reasons. The main reason, I think, is economic and availability. The economics of going into a co-op, I think the prices are generally better, if you will, for the same kind of units in a co-op than a condominium. Cheaper.
I understand that.
Yeah, right. I tried to stay away from that word.
Right.
But yes, cheaper. And also, it's availability. As Ken says, there are not that many condominiums in New York. Historically, New York has been a co-op city. The rest of the country has been condominium because they really started out with the garden apartment type of setup. And to translate that into a high-rise is something that is fairly recent to New York.
All right, let's talk about something recent. There have been indictments of managing agents. There have been real estate people who are now in prison for dealing with co-ops. Tell us about what your experience is with that.
Well, actually, I've never had the experience with that. We've had the boards that I've been associated with have all had bidding processes.
All right. Well, what I'm talking about, tell us what the this thing with managing agents and the illegalities, as you know it.
Well, the illegalities I know have been kickbacks or having
Kickbacks, what does that mean? If a contractor does work in the building, he gives a percentage back to the building?
Usually to the managing
The
agent.
managing agent. Was that something normally happening?
I think it was probably happening in the real estate business throughout the city, whether it was in co-ops, condos, or rentals.
Ezra?
Well, about a year and a half or so ago, the district attorney indicted several very prominent management firms for this very thing. Gifts, kickbacks, and so on.
What I want to know is, was that the custom and usage of the trade?
I think-
where there was a, normally, if you sold something to a co-op, you had to kick back a percentage to the managing agent?
I think that there was a culture. I don't know how widespread it is, and I don't think anybody really knows yet, but I think there was a culture that was that existed which operated on that principle. And one reason was, and this is something co-op boards don't like to hear, one reason was that the whole management industry was underfinanced in many ways. The fees did not really support the kind of personnel that you had to put into a co-op to do a good job. That's a very difficult position. It requires a lot of knowledge, and if you don't pay the person enough, which is, I think, what was happening, in some sense you're telling them, go out and do what you can on your own, and that's what led to these indictments.
Does that mean if a politician is underpaid, he has the right to
I didn't say the right. I just said it was a fact.
Okay, we're going to take a break now, but right after that, I'm going to talk about your board and what happens on your co-op. You're watching Lawline. I'm Alan Schnorman, your host. Stay with us. Hello, I'm Alan Schnorman, the host of Lawline, and I want to give you some important information about your legal rights. If you were seriously injured in an automobile, a fall down, or construction accident, you may be entitled to a substantial money award for your pain and suffering. It is important to speak to a knowledgeable attorney in that field. At my firm, Solomon & Schnorman, our practice is limited to personal injury law. We fight for the rights of accident victims. Don't try to evaluate the case yourself. If you have any questions about your accident, call us at 1-800-LAWLINE. If you're too injured to come to our office, we will come to you. The consultation is free, and we only get paid when your case is settled or won. Remember, the insurance companies have lawyers protecting their interests, and so should you. Hello, you're watching Lawline. I'm Alan Schnorman, your host. Today we're talking about co-ops and whether you should live in a co-op. With us is Ezra Goodman, a real estate attorney, and we have Ken Newman, who is president of the co-op board and also a real estate attorney. Is that correct, Ken? Before the break, I had asked you what happens in your co-op and the experiences. Now, here are people who normally, many times are not financial people, who are handling budgets in $6 and $7 million. What happens in your co-op? How much control do you have on yours? Do you have a managing agent?
We have a managing agent.
Okay, and does he, what does he do?
He is also the board president.
Wait, are you serious?
No, I'm very serious.
You're the managing agent?
Yes.
That's a somewhat unusual situation, and it's something that well, first of all, in some sense, it's a compliment to Ken, because he was the sponsor and stayed on the board and was in fact elected president, which is, as I say, very unusual. Most co-op boards don't run that course.
Let's take that one step at a time. You were the sponsor?
I was the sponsor.
Did that mean you sold the building to the people?
I did.
Okay, that means you're rich. You made a lot of money, right?
Well, I'm the representative of the sponsor.
Okay.
The sponsor's a partnership.
Okay, you're one of the partners. And then you became president, and now you're the managing agent.
Yes.
Do you get paid to be managing agent?
I do.
Now, isn't there an inherent conflict?
You might think there is, but it's a conflict that's fully disclosed and permissible under law. And in fact, most buildings, when they went co-op, the managing agent was controlled by the sponsor.
That usually didn't last very long. What happened when the residents eventually took control of the board is that usually there was a clean sweep, so to speak, and the sponsor's management went out. However, there is certainly a countervailing argument that the sponsor's interest, once the co-op is converted, becomes residential. The sponsor's interest is in many ways consistent with the shareholders' interest, because the sponsor, in this case, retains a substantial number of apartments, and what's good for the co-op is good for the sponsor.
Isn't there a law that says that the sponsor is limited in number of years that they can control the board?
Yes, but I never controlled the board. The board has been independently elected by the shareholders.
Right.
And generally speaking, I didn't vote my shares.
How many people are on your board?
Including for myself.
How many members do you have on your
I
board?
have 7 members of the board. The other 6 people live in the building. I do not.
No relations?
No relation.
No wife, cousins, brothers, partners?
Never.
Okay, so now
Never had one person on the board as a sponsor.
have you, how long have you been the managing agent of the building?
10 years. Oh, I've been a managing agent since 1972.
Okay.
It's 10 years since it's been a co-op.
Since 1972?
Right. And the board votes independently of me being a managing agent. I walk out of the room, they discuss it, they decide what term I have, the fee.
See, there's nothing inherently wrong with that, as long as the other directors are observing their fiduciary duties and, as an example in this case, putting it out to bid. I think what should be done in a situation like that is you obtain bids from other management companies to see what the going rate is, and if the fee being charged by the sponsor's management firm is competitive, and you're otherwise satisfied with the services, again, there's nothing inherently wrong, but it is unusual.
Ken, I have a few questions, if I may. What do you do?
I think you're turning this around into something about my particular
just
and
curious.
quite unique situation.
What do you do? What does a president do of a board?
Conducts the meetings,
Right. What else?
signs the papers that have to be signed,
Right.
has only one vote at each board meeting,
Right.
as do the other people.
And if I have a complaint, can I come to the president?
Frequently, the president is the lightning rod for problems in the building.
What does the
Yes.
managing agent do?
The managing agent collects the rents, pays the bills, hires contractors and employees, make sure the employees and the contractors are doing their work. That's not to say that I select contractors, because our contractors are all selected by bidding.
Okay.
I try to maintain as scrupulously as possible
Of course.
my position as a fiduciary.
Okay. Now, the problems that they had a few years ago with all the managing agents, to give advice now, you can give advice from many hats. You can give advice as a president, as a sponsor, as a managing agent. If there are people out there who live in co-ops, who are managing these budgets, what's your advice to them to avoid these things that happen with managing agents from overreaching?
Well, I think the problem is that not only were the managing agents underpaid, most of them thought that they would earn their money, the managing companies thought that they would earn their money by getting the fees that were generated by commissions, which were probably more lucrative than management fees.
I mean, it was so accepted that this was just understood?
No. When you sell an apartment, there's a 6% commission.
Okay. Oh, now I
So if you
understand.
sell $1 million apartment, there's a $60,000 fee.
Right.
So the managing agent companies were making so much money on the
Sale of the
on the
apartments.
transfers of the apartments that they were very interested in capturing that, which they thought they did and probably did in the past, much more so than today. And therefore, they were willing to take lesser amounts and pay lesser amounts to their managing agents,
Right.
inducing, as Ezra said, improper practices. But on the other side, the board members, being unpaid and hardworking people, generally didn't have the time to oversee these situations.
But how do we avoid it for the future? That's what I want to know. What's your advice to the co-op boards now to avoid this from occurring, when now that it's died down, the people are in prison, how do we avoid it for the future?
Well, if you have people like we do who are very familiar with contractors and constructors and construction and bidding processes, they can overlook it, as we do on our board.
Get involved. Ezra?
Well, there are several things that we've undertaken in response to that. First of all, it's not over. The district attorney promised another set of indictments this past summer, which has not yet materialized, but the investigation is, quote, continuing. So I don't think we've heard the end of it from the DA's point of view. But some things that we put into effect in our co-ops is we do have a contractor's reference and qualification statement that any vendor or contractor must fill out, which not only has references, but also has questions about past or present criminal involvement and so on. People may lie, but on the other hand, it is something that can be done. But the most important thing, I agree with Ken, is that the boards have to be involved. They have to understand, they have to have some general knowledge of where pricing should be, and be able to review bids, to make sure that everything that's major, at least, is bid out. And some of the biggest abuses weren't even in the major contracts, like replacing a roof or doing facade work. It was in buying supplies. You went into a hardware store and you bought supplies, small amounts, but over a long period of time it added up to a lot of dollars. And those were areas in which there were definitely gifts and other types of returns which were improper. That's much harder to control. But even there, you have to keep track of your inventory, make sure that things that are being purchased are not being purchased in unreasonable amounts, which is a sign of abuse. Make sure that you can account for inventory, that things don't come in and then just disappear. And on the large projects, very certainly, have competent architects draw specs, if that's the kind of job it is, or have even an insurance consultant draw a spec for insurance, and have bids, make sure that the bids are properly reviewed, everything is done openly, and come to a reasoned conclusion. That's about the best you can do.
Ken, what other advice can you give to other co-op boards throughout the city, and there are thousands of them, to avoid the pitfalls which you've encountered over the years?
Well, just pay attention to what's going on and get involved. They must get involved.
Yes, but
If they don't get involved, the managing agents take over, and they do everything, and they don't have the interest or the benefit from what they're doing to put in all that time. The people who live in the building are the people who will live and die with it. It'll be their money that's being spent. They must be involved.
One of the issues that, for example, that comes up in co-ops is the question of term limits. That's a hotly debated issue.
Term
Should there
limits
be
amongst
term
the
limits
officers.
on directors?
Well, you've been a director for how many years?
10 years.
All right.
President
But
for
I
how
will
many
tell
years?
you, 10 years. But I will tell you that in our co-op, there are very few times when we have more than 7 people running for board seats.
Well, that's the argument.
And sometimes we have to beg people.
Right.
And yet you have over
run.
100 units in your building.
137 units. The problem is that they're either too busy or too disinterested, or there aren't enough problems in the
Or
building.
things are going too well, which in some sense is a compliment if people don't come out to run. Usually what galvanizes people, is an issue. A maintenance increase that people get concerned about because they don't understand the justification for it.
Our maintenance has been about 3% on the average over the last 10 years, which I think is rather low. But the only time that we did have a number of people turn out for a meeting and to run for the board, we had maybe 2 or 3 extra people, and that's not a lot either. But the issue was on subletting. The board wanted to restrict subletting. A lot of the tenants who had been, or a lot of the shareholders who had been subletting for many years didn't want that to end. And we had too many sublets for our building and to refinance our mortgage, and for other shareholders who were selling to get people.
How did you
who
come out on that? Did
could come in.
you keep your restrictions on subletting?
We kept our restrictions, and we had, unfortunately, antagonism, but mainly from the people who were subletting, not from the people in the
Kel,
building.
I have a question. How much power do these boards have? Can they, let's assume this particular board loved artwork, loved expensive artwork. Can they go out and buy a magnificent painting for the lobby at $25,000 of my money?
I would say that they have the power to do that, yes.
And what
Well,
I-
I would disagree with that. There is something called the business judgment rule, which is a very important case that was cited in New York, which said that as long as co-op boards act reasonably, even if they're wrong, then they can't be sued and be held liable. So there is, some protection. However, in any particular case, a court is going to impose a test of reasonableness. And going out and spending money that the co-op may not have on something like artwork
Well, let's assume they
may
have
be
it, but
questionable.
Let's
Wait,
assume
I
they
said
have
they
it,
have
but
the-
I think it's ridiculous.
I said they have the power to do it.
Yeah.
They have the power to do it. To stop them, you have to bring a lawsuit.
Well, don't they have to ask the shareholders, can they
No.
spend $25,000 on a
No.
painting for the lobby?
No, legally, the board does not have to go to the shareholders for anything other than elections, and if they decide to sell the building, then you have to get a certain vote under the statute. But other than that, the board of directors, Ken is right in that sense, the
Now-
board of directors has complete authority.
By the
Whether
way,
they'll
on
be held
major-
accountable for it is another question.
On major issues in my building, like subletting, on hiring a doorman for longer hours, we always go to the shareholders to find out what they want to do.
For informational purposes.
For information.
Now,
Always
Which is
call
a
the
dangerous
shareholders.
thing to do, by the way.
Some
It
boards,
may be dangerous, but we always feel that we're
As a-
operating for the shareholders.
some
Therefore, they
boards
should be
don't
involved.
allow any financing for anybody to purchase a unit in that building.
Right, and that affects the marketability of their apartments, and I think that is something that is part of the old guard co-ops that exist on Park Avenue. I don't think very many
Quickly,
newer
Ken, what do you
co-ops
want to tell anybody who wants to be a board president or a member? Quickly?
Be strong.
Ezra, in summation?
Co-ops, I think, are a wonderful way of life, and I think that they've gotten a bad rap.
And you heard it here on Lawline. Ezra Goodman, thank you very much for being on Lawline. And Ken Newman, thank you for coming on Lawline and playing a little devil's advocate with me. And as always, this is Alan Schnorr, and thank you for watching Lawline.
You have been watching Lawline with your host, New York trial attorney Alan Schnorman. Mr. Schnorman will be back with you next week at the same time. If you have any questions about this week's program, please write to Lawline, 63 Wall Street, New York, New York, 10005, or call area code 212-432-9111. This program was made possible by the law firm of Zalman and Schnorman, whose practice is limited to personal injury and insurance law.